Hi, and welcome to All Things Divorce Podcast. I'm Launi Sheldon, the host of All Things Divorce Podcast. Today I have with me Dan Riley, and Dan is going to talk to you about QDROs. So it's a Qualified Domestic Relations Order, and he's going to explain that further because I definitely can't. So a little bit about Dan. He has been practicing since 2008 and has really focused his area on QDROs. He is a certified family law specialist, and he's a certified QDRO specialist, which is kind of a rare combination, Dan. Is there even anyone in Arizona who has has both of those?
I don't believe so. I'm not sure if there's anyone else in the country who
Yeah,
has
I'm
both,
not sure
actually.
either. Yeah, that's not something you usually see. You don't usually see someone with a family law specialization certification along with the QDRO. So, okay, so Dan does mostly focus on his QDRO work and dividing retirement assets, and that's really what he's going to talk to you and explain to you what a QDRO is. And then again at the bottom, I will add his at the description on the podcast and the YouTube. I will add his information. But Dan, if you need a legal expert to testify for your QDROs, Dan's the person. That's where he focuses his scope, and he can help you out there. So as usual, listening to this podcast does not create an attorney-client relationship between either myself and the listener or Dan and the listener. And Dan and I are both only licensed to practice in Arizona, though some of this information can be used outside. I mean, I think QDROs are national, right, Dan?
They are, yeah.
Okay, so, but Dan's certainly not, this isn't an advertisement for Dan to get work outside the state. But again, can be useful in your jurisdiction. So if you have an attorney in another state, feel free to talk to them about what you learned here today, because he is going to talk about some mistakes. So he has some of his favorite mistakes that get made, or maybe least favorite mistakes that get made, some messes that he has to clean up. So welcome, Dan, and thank you for being here.
Oh, thank you. Yeah, it's great to be able to chat with you.
So talk to me about what a QDRO is. So as a family law lawyer, we call them QDROs, but what are they and what does it mean?
So it's an acronym. It stands for Qualified Domestic Relations Order. Technically, a QDRO is really only an order that divides certain specific types of private sector plans, but it's one of those terms that just gets used as a general term to describe any order that divides any kind of retirement asset or deferred compensation. So it's kind of like how we say Kleenex as just a general term to mean tissues, even though that's a specific brand. We use the term QDRO to describe any order dividing a retirement account, even though technically it only means an order for certain specific types of accounts.
Well, and that's honestly a really good point that you brought up, because what actually needs to be divided by a QDRO? What specific types of retirements?
The most common plans are going to be your 401k plans, municipal pensions, but you can see QDRO-like orders for all kinds of other plans: restricted stock units, health savings accounts, even brokerage accounts. People will send brokerage accounts for me saying, all right, do the QDRO for the brokerage. They technically don't need one, but the math is pretty similar. So I'll do a QDRO-like order to divide a brokerage account. Any wonky type of financial account ends up with an order that looks a lot like a QDRO.
Okay, great. So, so you have some, I don't know, are they pet peeves too? But you have just the mistakes that you see, which again, I just have to tell the audience, I practiced in litigation for about 18 years. And I never once did a QDRO by myself. I always sent them out because they are very specialized. So do you see attorneys that aren't special, like, I'm not going to say not specialized, because I know there are attorneys who aren't specialized that do QDROs, but I think it's rare that you see like litigation attorneys doing QDROs, right?
Some retirement plans will have forms that they will offer that people can fill out to sort of prepare their own QDRO. And I've seen attorneys fill those out. The thing to keep in mind there is that the plans prepare those orders to make it easy for them to administer. They don't prepare orders that are going to be specific to your state's community property laws, or that would really be considered fair and equitable if a court was trying to decide whether this order should be issued. They're just doing it for the ease of them being able to administer QDROs without having to spend a lot of time and effort. So I do see attorneys fill those forms out with results that can often be a bit strange.
Oh, well, that's interesting. Okay, so what is maybe the most expensive mistake you've seen happen?
The most expensive mistake. So we have here in Arizona, we have several different municipal pension plans. We have Arizona State Retirement System, Public Safety Personnel System, and the statements that employees get for those accounts look a lot like a 401k plan statement, but it's a pension. It's not a savings plan. So they'll get a statement that says you've contributed $80,000 to the pension system. And sometimes attorneys will look at that and think, okay, there's $80,000 in an account, and they think that's the value of the pension, and it's absolutely not. So the most expensive mistakes I've seen have been when people have mistaken a pension for a 401k plan, and they've assigned it a value based on the contributions that have been made to the plan, and then they're offsetting it with other things. So I had one recently where they said, the Arizona State Retirement System worth $88,000 shall be offset against the other party's 401k that has a balance of $40,000 with an equalizing rollover from the 401k plan. And when I'm brought on board after the fact, my role is just to implement what's in the decree. It's not my job to rewind everything, to blow up the agreement.
But can you even do that? Can you even split? Because that 80,000 is not sitting there for you to take out. So
No,
how do you implement that?
Yeah, so in that one, the 401k plan, I apologize, the 401k plan had about $100,000 in it. So they were equalizing it by saying take 10,000 out of the 401k and roll it over to the person who had the pension. So I calculated what the actual lump sum value of that pension was, and it was worth almost $700,000. So that's a $600,000 mistake in the drafting of that.
Is it just a young lawyer that?
No,
Oh.
It's this is one of the weird things about in general with what I do is a decree will be very detailed about something that doesn't have a lot of value, year, make, and model of an old used car. But then when it comes to a retirement plan, it's worth hundreds of thousands of dollars. Almost no thought is given to how should we describe it in the decree, what kind of disclosure and discovery should we do. So it's often very perfunctory language that goes into the decree. And I think the thought process is, well, the QDRO attorney is going to sort it out. But sometimes
there's
can't sort that out.
Yeah, I mean, you have an order and you're just supposed to do what the order says. So
right.
You had to be in there just, I don't know, like calling all your friends going, oh my gosh, you're not going to believe this.
Yeah, it was, and it's not the only time that I've seen that. It's actually a fairly, I'll see it a couple of times per year where someone will mistake a pension for a 401k plan.
That's horrifying. So are there any other like expensive mistakes that you see?
Other really expensive ones. One of the issues that rarely gets addressed by trial counsel is the question of direct payments. So when we have municipal pensions, they're a little bit different in that the former spouse can't start to receive his or her share of the pension until the employee actually stops working. And in Arizona, we have a case, Kelch versus Kelch, that says in that scenario, the former spouse is allowed to go to court and ask for direct out-of-pocket payments that are calculated based on what the person would be getting from the pension if the employee had left employment. And that can be really valuable. Especially
and if you ever decide that you want to do another podcast and you're comfortable with Kelch, I would love to have you talk about Kelch, because that's a really interesting case that can really, I mean, I understand it. I get exactly why they have it, but boy, that can be tough for the employee for sure.
Yeah, I see both sides of it.
Yeah.
On the one hand, I see why it's it's fair for the former spouse who shouldn't necessarily have to wait for the employee to retire and be completely beholden to their employment plans. On the other hand, I've seen several times where having to make that couch payment forces someone to retire when they like their job, they're moving up in their job. So especially police officers, I've seen them have to leave employment, and then oftentimes they'll go get a job somewhere else, maybe for the federal government or for a city government doing some kind of investigation work because they can't afford to make those couch payments.
Yeah, that's a hard one. I've had a couple of cases with that, and it's a really difficult one. You know, so that is a really tough one. But what about military? Because military's super tough, also, right? I mean, I don't even used to give those cases to other people because that's a hard one.
Yeah, the military plans. I saw a statistic. It was an interview with someone over at Defense Finance and Accounting Services. This is the government agency that approves orders for military plans. And they said more than 90% of the QDROs that they receive, they end up kicking back because it's so difficult to draft an order that actually meets the conditions of the military plan. So in 2017, Congress changed specifically only for military plans. They changed the formula we're supposed to use to figure out what a former spouse's interest is. And now we're using something called a frozen benefit formula, where basically we look at what was the person's rank and pay grade on the date that they got divorced. And then we calculate sort of a hypothetical retirement benefit. If they had been allowed to retire on that date, what would their pension have been? And then what would be the community portion of it? The result is the former spouse always receives a significantly smaller amount than they would have received under a traditional, what we call a pro rata formula. Where we're
Right.
just looking at the final retirement benefit and we're multiplying it by a ratio, looking at the length of marriage that overlaps with employment, divide that by total service, and that gives us the percentage. So the frozen benefit formula, what I use to explain why it's so different is you could have a service member who serves for 20 years and is married to 4 different people, each for 5 years, all during that 20 years. You would think that, well, they were married for the entire 20 years. So at the end of the day, it would all really be community property. It's just a question of who's getting what share of the community property. So the service member should get 50%, and the other 50% should get split between those 4 former spouses. And really, when you do the frozen benefit formula, it works out to be the military member would get more like 75%. And then the person they were married to most recently would get a bigger amount than the person before them, who would get a bigger amount than the person before them. So it's a very strange way of doing things. It's totally unique to that retirement plan.
Well, that is also interesting because what if they've only been working for 15 years and they're not set for retirement yet, and then they get divorced at 15 years, there's no retirement there. Do they get anything?
So when they're calculating it, even though with military retirement, they have what's called a 20-year cliff vesting schedule, meaning if you don't hit 20 years, you get nothing.
Right.
But in terms of calculating what the former spouse's share is, once they hit those 20 years, let's say they were married for 15 of the 20 years. They calculate it by saying, okay, what if we allowed that person to retire at 15 years? What would they have received if we had an early retirement program for this pension? Which they don't, but they calculate it as if there was an early retirement benefit, and then they figure out the percentage. So it ends up being it always ends up being a lesser amount for the former spouse.
Okay, so the former spouse would get less through the military than they would say like Arizona State, right? The state, just the way they divide it.
Yes, and then you factor in with military, there are several different types of disability programs, and a lot of them, to qualify for it, you have to agree to exchange $1 of your retired pay. So if you're getting $500 disability, you're waiving $500 of your retired pay, and disability doesn't get split with a former spouse. so they can reduce their retired pay, and that reduces the former spouse's interest also. There are lots of different weird little mechanisms that make it really hard to draft those military.
Yeah,
orders.
and now the way you said it is they can. And so I'm wondering, is that sort of a choice that people can make, either the litigant or the military? Do they have options in there to choose? Okay, look, you could probably qualify for disability, even if they weren't gonna. You probably qualify for this much in disability. So let's do that so that it lowers your retirement. So do you notice that as an intentional way of lessening the amount that they pay?
I don't necessarily think that people are using gamesmanship with it. I think it's always financially beneficial to waive retirement in exchange for disability, because you don't pay income tax on the disability benefit. So a lot of times it's actually a surprise. I'll get phone calls, a couple who divorced, it was totally amicable, they've got kids, and they're both calling saying, I don't know what happened, but the payments went way down for my former spouse, and I can't get anyone at Defense Finance and Accounting Services to return my calls. And 99% of the time I ask, did you just get approved for disability? They say, yeah, but that's a separate payment. Yeah, technically it's a separate payment, but you're waiving retired pay to get it. That's why the other person's payments went down, because in terms of accounting, your retirement went down and then your disability
Right.
went up. So
Interesting.
so the service member sees the same amount every month. To them, it doesn't look like it changed, but the former spouse is saying, whoa, what just happened? My benefit went down to $20 a month.
Oh yeah, that would be clearly frustrating, especially when they based maybe a decree on what they anticipated that they were going to get for the for the duration of the retirement or pension.
Yeah.
So tell me, do you have any interesting cases through appeals that that you can kind of talk about?
Yeah, I've got two that are fairly interesting at the moment. One is it's an administrative appeal in federal court under the Administrative Procedures Act, involving the interpretation of the military retired pay statutes. Because when Defense Finance and Accounting Services disallows a domestic relations order, there's an administrative appeal process, and then if you exhaust that appeal, you can then take it to the federal district court. It involves I represent the former spouse. The service member has now died, and Defense Finance and Accounting Services is telling my client she's not entitled to a survivor benefit because, like a lot of military marriages, they married overseas, and they got divorced overseas. And so they're saying, well, your foreign divorce decree is not a court order within the meaning of Title 10 under federal law, which it has to be a U.S. order. So we domesticated the order in the United States, and they're still saying, well, that's just a domestication. That's not your divorce decree. You have to get divorced in the United States to be able to qualify, which we think is an incorrect interpretation of the law. So that one's pretty interesting. We have another case where we're going to trial next week, where I represent the former spouse. The military service member accrued almost 20 years for a military benefit, and then left military service and started work for the federal government. Well, in the federal government, you can take your years of military service and you can add those to your federal pension. And they've taken the position that, well, the decree only awards a portion of the military retired pay, and that no longer exists. So you get zero after 16 years of marriage. And
is that the ex that's doing that, or is that is the ex fighting it, or is that the government that's fighting it?
It's the service member spouse. So okay. He's taken the position that, well, the decree awarded you military retired pay, and there is no retired pay, therefore you get nothing. Well, but really there is military retired pay. It just got converted into a new pension system. So
now is that on appeal right now?
That one's going to trial. So that one's still at the trial level, but
that'll be interesting. I hope you'll keep us up to date on that one, because that's you know, again, the gamesmanship in litigation is what it is, right? I mean,
Right.
everyone's
Yeah.
trying to get what they can get. That's really interesting. And I after I kind of want to ask you a couple more questions, but then I want to kind of dive into some more stuff like advice that you can give people, because, you know, about, at least in Arizona, 85% of people are unrepresented litigants. So we've
Right.
got to they need your help too, right? I mean, they need your help even if they're not represented. And so I kind of want to talk to you about that after this, but are there any, like, because there's issues that come up, are there any changes you think that could happen in QDRO law that you think might be, you know, pending? Or
There is certainly an effort to change the law here in Arizona to adopt that same sort of frozen benefit formula we use for the military plans. There's an effort to change the law to adopt that for our municipal pensions here in Arizona. It's been tried a couple of times through the courts to reverse the law about how we divide retirement benefits, and that hasn't been successful. So now there's an effort to try to change it through a change in statute. So I don't think a bill has been introduced yet, but I'm aware of a lot of lobbying going on to try to change the statute.
Here's one that, now I'm just going to throw this at you just because it affects me personally. You know, my husband is a retired judge, and so he's also a divorced retired judge, right? So he split his pension with his ex-wife. But what I think is really crazy is that when he dies, I get his part and I get her part. And that's, I think, the craziest thing ever. Super unfair. I mean, I don't know that anyone's going to stand up and say, change this, because I don't know that the spouses really understand it. Does that make, I mean, it's crazy, right?
Yeah, and I before I got into this work, I used to always wonder, how was it that all these government agencies and corporations were able to get employees to buy in to switch from a pension system to a 401k system, when a pension system is so much better for the employees. And what I'm realizing is it's because no one understands how a pension works. Even employees, they go, I don't know, I get something when I retire, I don't understand it, it's some kind of math formula. But being able to look at a 401k statement and go, that's how much money I have, and I
Right.
can watch it grow every month. It's the certainty of being able to look at it and know how it works. Now I totally get it. Yeah, because pensions are so wonky. They have, like you just mentioned, some of them have these weird reversionary interest rules. And they're all different from each other. They all have weird little mechanics to them. That's why people just are switching to IRAs and 401ks, is because at least they understand those.
And I think if it's a 401k, you know, it's less likely that they're not going to receive that benefit. It's less likely that they're not going to lose that benefit if the state goes bust, right? So like if Arizona went bust, his pension's at stake. I think that happened in Illinois, right, with some people several years back.
I don't know. I hadn't heard of that.
But I think it was at least a threat that it was going to happen. And so at least I think with the 401ks, you lose that fear, right? Because it's already in your name and you own it. So maybe that, but so okay. So what I do want to ask you kind of what advice you have for people who are going through this without an attorney and they need to figure something out. What advice can you give them?
Yeah, I think the biggest piece of advice that I would give people is to keep in mind that your retirement assets are probably your most valuable asset. So if there's one area where it's worth it to invest some money, to get some advice, it's going to be with dividing their retirement assets. And they should probably do that before they're submitting their consent decree. Because like with the example I mentioned earlier, something as simple as saying the Arizona State Retirement System valued at $88,000 has now completely gutted the ability to fairly split that account. And I'm sure they didn't understand that when they did that. So getting some advice from a quadro attorney before the decree is signed, even getting your quadros drafted and submit them with the consent decree. If there's one place to not cheap out and to spend the money to have it done right, it's going to be there.
That brings up another point that I want to ask you about. So I recall going to a CLE on quadros once, or I don't know, somebody was talking about the quadros. And there was an issue with doing it too late. And then, like, for instance, they put in the decree how it's supposed to be separated. The spouse gets married, both, they're divorced, and the spouse with the retirement gets remarried and then dies. And the pension hadn't been split, and now this person received the benefits because they were the surviving spouse. So can you help that by doing it in the decree by having it done prior to the decree?
Yeah, there are a lot of problems that can come up when people are waiting too long to get their quadros done. That's one of them. I think estate of Lamparella is the case that you were just talking about there. And yeah, that was a situation where they didn't do their quadro. The employee spouse remarried, designated the new spouse as the beneficiary of the survivor benefit, then died, which meant the new spouse got the entire survivor annuity. And there was no way to rewind the clock and have any funds go to the former spouse, even though that's what she'd been awarded in their decree. Another problem people bump into is retirement plans only have to keep statements for 6 years. And so I've seen several situations where someone has a premarital interest and they can't get statements going back far enough to calculate it, or they get divorced and they wait more than 6 years to do their quadro. Well, now it's impossible to calculate what was in the account when the divorce happened. And so now they have to split all these post-marital earnings because the burden of proof is on the person who's claiming they have a sole and separate interest. So there are lots of problems that can come up when people aren't doing their quadros right away.
So, and I know we've seen this hundreds of times. Well, I quit this job and I went there and I transferred this into that. And they have one piece of paper from one business from a retirement fund that they had with another company. And so they know there was, $3,000 in there but that was 30 years ago. And what did that equal, up? So do you recommend that people actually hold on to copies of every, look, no one's planning on getting a divorce,
right?
But no matter what, I mean, even if you don't get divorced and there's some issue, you're going to want your statements. So would you advise that they just sort of keep them forever?
Yeah, that would be one option. Would be to keep the statements. I had a case recently where I was able to figure out what someone's premarital interest was because they had signed up for I think it was mint.com, and that sort of stores information forever. And so I was able to see, okay, this is what they had in the account when they got married. Here are the contributions they made during the marriage. Here's what they had when they got divorced. And so I was able to use the information that was stored in mint.com to calculate what the community portion is. But yeah, we sometimes have to get really creative in figuring out premarital interests because people are typically married more than 6 years before they're getting divorced and splitting retirement assets. So sometimes people will have a spare statement lying around here or there. And it will at least show me generally what they were invested in, and I can look at stock market trends to try to estimate what the growth on it was. But it's always better to have the actual statement because I can calculate down to the penny what the community property interest.
All right, people. So you heard it here. You need to keep your statement so that you don't get screwed out of
invest in a file
separate
cabinet.
property. Well, I mean, seriously, digital, you can keep all your digital stuff easily. And it's kind of surprising that banks and stuff don't do that, don't keep them longer now, since what's the harm? If
Right.
let me pay them an extra $20 a year or something to let me keep more of my files. It's so easy now. It's not as if they're having, file cabinets filled with upon file cabinets upon file cabinets that are filled with information. Well, Dan, thank you so much for being here. I appreciate
It
it.
was a pleasure. Thank you.
Do you have anything else you want to tell anyone about QDROs? Just sort of, don't do stupid stuff. I was going to say it, but I didn't. Don't do stupid stuff, and at least consult with a QDRO attorney, you think?
They're so bizarre, retirement accounts, the way the court treats them. It's so easy to make a mistake and not even realize that you're doing it. It's worth it to consult with an attorney who does this stuff.
Hey, I know we wrapped it up, but I do have another question now that I just was thinking kind of what you were saying. Is it okay for both parties to consult with one QDRO attorney, or is that problematic? Because I know some people go, oh no, we can't use that person if you recommended them. But really, as a QDRO attorney, you work for both parties, right?
90% or more of my cases, I'm working for both parties. So
Okay.
I'm more in the role of a mediator, explaining to them how their retirement accounts work and what I think are some options for dividing them, and then ultimately getting their agreement on how things are. So the 90% of cases I'm jointly retained, and I'm explaining to them, nothing you tell me is privileged. If you tell me to keep something from the other person, I have to then back off of the project.
Oh, well, I was gonna stop recording right there, but then that got interesting. What would somebody tell you that would cause you to do that?
If they then reveal that there's another account, I didn't disclose the statements for it. It's not in the decree, so therefore it's mine alone. I go, well,
Ooh.
no, it's not, because there's a statute that says information that wasn't disclosed, that is discovered after the fact, it's considered to be community property. And then they tell me, well, don't tell the other person about it. I said, well, I have to just withdraw, and I have to do what's called a noisy withdrawal from the project, saying, as per the agreement, you both agreed that nothing you told me would be considered privileged. I have been asked to keep a piece of information from the other party that I believe is significant and relevant to the project, and this prohibits me from proceeding any further. And then the other person knows, okay, they're going to take that letter to an attorney who's going to interpret that and go, there's another account out there somewhere.
Yeah, wow, hopefully. Have you had that happen?
Oh yeah.
Oh my gosh, that's crazy. That's
Yeah.
Hopefully it wasn't money in my cases, but because you never know. You don't know what you don't know as an attorney.
Right.
You don't know these people's lives for the last 50 years or whatever, if they had something. Well, thank you so much for being here. I appreciate it, Dan. It was good to hear your explanations.
It was a pleasure. Thank you.